Hi there, welcome. I'm Billy Tarasio. This is Julie LeBenz. How's everybody doing today?
We're doing awesome. Billy and I are lawyers in Arizona with, nearly 2 decades of experience now. We were two of those, went straight from college to law school and started practicing law. So,
Yeah.
even though we aren't, seniors or anything, we are very experienced in the law, and we've been doing
We're
this
in
for a
our
long time
prime,
in
Julie.
Arizona.
We're in our prime.
Yeah. So, Billy, what do you want to talk about today?
Well, today we're going to talk about domestic violence. It's great because I've got stuff I want to talk to you about. I want to get your ideas on. I've got strong feelings, and I think it's a complex issue. And so I really want to talk to you about that. I wanted to know, how's Win Without Law School going? I know that our members are up, our number of subscribers are up. Tell me how it's going.
It's going really well. We are coming into the end of the 10-week teaching series, where I've gone through how to represent yourself in a case from start to finish, whether you're in a divorce, custody establishment, or a post-decree or post-order case. And then also along the way, we've talked about more in depth on trial skills as well. So this week we talked on Monday about discovery. And then on Tuesday and Wednesday, we talked about your settlement options. Your case is pretty far along. You've engaged in disclosure. What can you do now to try to resolve it and save yourself from, facing a trial? And so we went through that. And then in the final weeks of Win Without Law School, we'll go more in depth on trial skills and what to expect and pretrial statements. But we already have a ton of content on that topic already. So obviously conducting yourself in court is one of the most challenging things for a self-represented party. And we have so much material on that point.
That's good. That's great. I don't think that there can be too much. And I've looked, there is a lot of information, but I love the way it's organized in a way that is digestible, consumable, and learnable so that you can actually apply it to your case. And I love hearing from our members about how it's working.
Yeah. And Billy, you did a workshop last week. So tell us about that.
It was great. It was great. So we had 3 different members from Win Without Law School workshop their issues. So we talked about their case. We talked about roadblocks. We brainstormed about what they needed to prove, how they would get there. We talked about different discovery options. We talked about different tactical options. It was really, really good because there's no way that somebody who's representing themselves can be looking at things the same way as getting your peers involved, getting an experienced attorney involved, just getting other perspectives. So I think it was super valuable.
Yeah, I love the group dynamic because you'll get so many different perspectives, not just theoretically, but what people have actually lived through.
Yes.
And how they felt when something happened, or their experience, or how they solved a certain problem. So the group dynamic is really cool.
Yeah, it is. For those of you just joining us, Julie and I do this every single Thursday. We've got a topic of the day. We talk about that for about half an hour, and then we field your questions. So you can leave your questions on TikTok, on our Facebook group. If you want to make sure that you can watch the last ones, you need to join the Facebook group. That's Decode Your Divorce. And all the usual disclaimers. We're not your lawyer. This is not legal advice. It's just legal information. Seek out a lawyer in your jurisdiction for actual legal advice if you need it. So today's topic is domestic violence. This has been I'm excited to talk about this because usually when I talk about this, we talk about the statute, but I don't want to talk about the statute. I want to talk about practically what I see happening and what we can possibly do about it. So let's start with this. And I've gotten permission from my client to discuss this. Earlier in the week, I did a deposition of a doctor who had done a comprehensive family assessment. In this comprehensive family assessment, he wrote, there was overwhelming evidence that my client had suffered domestic violence, sexually, financially, coercive control. We had an expert report. There were witnesses that said, what my client said. It was pretty obvious, but the finding in the CFE did not say that. The finding said, well, there's allegations of DV by both parties during the marriage, because dad would say, well, mom did blah, 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 blah. And so neither one of them, and because they're both loving parents and there's no allegations of child abuse, neither of them should be awarded a benefit of the custody presumption. So, and I see this happen in court all the time, when judges will say, basically do whatever they can do to avoid applying the presumption that exists against giving legal decision-making, joint or sole, to someone who has committed significant domestic violence. So I did this deposition and the evaluator admitted it. He admitted that, yes, he knew mom was telling the truth. Yes, he knew dad was abusive multiple times, but he really thought it was best for the kids to have mom and dad involved as much as possible, if not all the time. And he knew that by making a finding of domestic violence, that he was creating that impediment for dad, and he didn't believe that that was in the best interest of the children. So what has happened is, you may have heard of the law, Kayden's Law. Have you heard of this?
Mm-hmm.
Okay, do you want to describe what that is?
No, go ahead. Go ahead.
Okay, so it's a law that is, you know how sometimes laws get proposed in multiple states that are named after somebody because a group gets together and proposes a law. Kayden's Law came after a little boy named Kayden who was killed by his father in a post-divorce situation where mom had been sounding the alarms of domestic violence. The court knew about it. They still gave him unsupervised parenting time and the child died. And that's not an unusual story. And because it happens more than sometimes, because it happens with some frequent regularity, that's where you get these custody presumptions. That's where you get the laws like the one we have in Arizona. So we have already the ideal law that they're trying to get passed in other states that creates presumptions and protections for children. That law exists. It's ARS 25403.03. But because that law and its presumptions conflict with other evidence and cultures and presumptions regarding co-parenting and moms and patriarchy, like what I'm seeing play out is I'm seeing judges and evaluators literally work around the law to avoid its consequences. Are you seeing this?
No, I'm not seeing it on the level you are. Obviously things in Maricopa County are different, but I have throughout my career experienced this just true fact that the courts are reactive. They don't necessarily take proactive steps to protect children. They more react after something bad has happened. And so I can see where this is happening in a lot of your cases where the courts are like, well, that happened in the past. Let's start fresh and see how it goes. And that see how it goes, unfortunately, often puts the children at risk. And this happens over and over again. And I tell my clients, it's like, yeah, we likely are going to have to wait, unfortunately, until something bad happens to your child before we have a strong enough case to get the court to change things.
Yeah. And in the case that I was just talking about with the CFE, my client isn't even trying to restrict dad's parenting time because there is evidence that he is a good dad. She doesn't really have concerns. I said sexual, financial, coercive control. She's not even trying to restrict his parenting time, but they had to call her a liar in order to avoid the presumption against joint legal decision-making. Like, that's a problem. That's a problem. And then in another case, I was talking to a client who's been a client at Modern Law for a long time, and she got this ruling where this judge basically accuses her of alienating and making things up for things that have happened over the years when she wasn't even the one to call DCS. Like, other providers called DCS because of actual real concerns. But I think what's happening is you have studies that show, let me just silence this because I know that we've got a lot of questions coming in. You've got studies that show that, generally speaking, equal parenting time is best for children. That those studies exist. And so courts and judges and psychologists are trying to incorporate that reality. And they're having, I think, a really hard time balancing the other reality, which is how do we actually assess for risk? And how do we apply the the domestic violence statute? Because it could be applied without calling my client a liar. You can still go through the steps and find that domestic violence happened between the parties, and also follow the steps and find that parenting time is not a risk. And here's how we're accounting for that. That's what the statute says, but that isn't happening. And instead, I see women being called liars.
And the statute refers to significant domestic violence, but I don't believe I've ever found a definition of that, either in the criminal statutes or in the family statutes. So we're supposed to prove significant domestic violence, but we have no idea what that actually means.
Right. And I think in working with enough of these cases and enough of these experts, I think what it is, and reading, so I've read a lot of the like APA guidelines for child custody evaluations. There's a difference between a pattern of intimate partner violence, which includes coercive control, it includes financial manipulation. It's a relationship dynamic of power imbalance. And I think that which continues after the divorce is a risk to the co-parenting relationship and to the children and to the victim. And so that is where you really need the protection of final legal decision making because of the power dynamic. But when you have two couples who don't have a power dynamic imbalance, and they might have had some heated arguments and pushed one another, that's not significant domestic violence insofar as it would risk the ability for people to co-parent successfully after divorce. That's just my own theory.
Yeah, and I think a lot of people don't understand, this spectrum of domestic violence, because if you get into a fight with your spouse or co-parent and you yell at each other, technically that is domestic violence. That's disorderly conduct per domestic violence, disturbing the peace of another person through.
Yeah, it could be.
So, and that can happen a lot. And so I think that judges are kind of looking at, okay, was this a yelling fight between mom and dad? And if it was, then they want to know, were the kids present?
Mm-hmm.
Whether or not the children observe the domestic violence is a big deal for the courts. I've found that versus just being behind closed doors. And, then there's allegations of, I was injured, but then, okay, is that an accurate picture? Is that really what happened? Is that a bruise from that? Or sometimes there'll be bruises on the children, which can be really tough because children get bruises all the time. So is that evidence of violence, or is it just evidence of a child being a child? So proving the domestic violence can be tough, especially if you don't call the police and there's no actual police report or criminal charge. Mm-hmm. So I agree with you, Billy, that it needs to be a very strategic decision. And even if you have a ton of evidence, you may still want to come to the negotiating table and find some way to work things out.
Yeah. And I do think it really comes down to, in litigation, you have to decide if are your kids in danger? And if they're not, is it worth it? Even if you were the victim of domestic violence, is it worth it? And that is an individual decision, because for some women getting out of these relationships, they're done being silent. They're done. They're not going to say, no, I wasn't the victim of domestic violence. They know they were, they have proof they were, and they're just unwilling to, because it's a required statement. The statement is, was there domestic violence in your relationship? When you get a divorce, you have to write it down. And I've had clients who are like, I'm not going to write, no, it happened.
Interestingly, I've probably represented more men falsely accused of domestic violence
that happens
in my career than women who were victims. And I had a case that actually went all the way to the United States Supreme Court that started out with mom going to dad's house, having a little pool party, and hitting dad with a beer bottle, and then calling the police and saying that dad did it to her. Wow. And this unleashed years of litigation. And ultimately we were successful, but of course my client was arrested. He was charged with domestic violence. He had to face the criminal case. And then she used all of that to get sole custody of the child on a temporary basis. Like, we had so much stuff we had to undo because everybody believed her initially. And eventually we did undo it. And my client ended up getting sole custody, and the daughter recently graduated from high school and has an amazing relationship with her dad. And the mom totally disappeared in the long run. So it somewhat worked out, but for a while there, it was really tough, and tens of thousands of dollars in legal fees undoing everything.
Because to prove it happened or it didn't happen, either way, if you are proving you've been falsely accused or proving it happened, either way is a massive undertaking. Massive. You need evidence. Like, proving somebody's a liar is hard, but you can do it. How did you end up proving that this mom was a liar?
So, gosh, this was so many years ago, so I don't remember exactly what we did, but a lot of it was really taking apart the police report and finding every little issue with it that wasn't completely accurate, bringing in other evidence to show the truth, and then really showing how this was just a facade to try to take the child away permanently. And so there was a lot to prove, and it took a long time too. It wasn't like we had one hearing and all of a sudden the truth was revealed. It took a long time, and it took mom kind of getting crazier and crazier for people to be like, okay, yeah, something's not right here.
Yeah. I also think one of the most convincing aspects to me is, like, who is this person with others? Like, if the picture that's being painted of this person is so different in the relationship than it is with the rest of the world, you can kind of tell that they're lying. Versus, does mom have conflict with everybody? Is this the first time mom's been accused of this sort of thing, or is it part of a pattern? Because really, these are personality traits that are not unique to one relationship.
Yeah. And, I always encourage people to get out of the relationship as soon as possible. Domestic violence starts somewhere, be it verbal, emotional, sexual, financial.
Pushing.
And so this is really a matter of self-worth, beyond the court system, beyond all of that. I think that, you really need to find your self-worth and decide when enough is enough. And of course, it's not always that easy if you're in financial bondage and, all these other reasons. But ultimately, expecting the court to solve your problem isn't always going to be your best bet, unfortunately. I wish I could say, oh yeah, just go to the court and they'll figure it all out for you. But you never know. You have this, your client who had amazing evidence, so much proof of domestic violence, and it didn't end up really changing the outcome. It just increase the litigation, it sounds like. So, obviously arguing in court, presenting your case, protecting your children is all important, but sometimes you have to really find the inner strength and do what you need to do on your own, because the courts may or may not back you up.
Oh, I completely agree. Another thing that I have learned is the process that takes someone from being, a healthy, normal individual to someone who is a real victim in a very coercive, controlling, terrible relationship, who allows themselves to be treated terribly, is the same psychological process as any other grooming process. It starts with boundary breaking. It starts with embarrassment and shame. It's the same thing. And so if you are in that situation, if you know that you're in a relationship that's not right, that you're not being treated well, understand this is not going to get better. It is not going to get better. It is only going to get worse. And having children with somebody who treats you that way sets you up to be connected with them in a toxic, terrible relationship for a long time. And I know it's so much easier for people on the outside to say, but maybe somebody's listening who needs to hear that.
Yeah, I mean, definitely. And I think when you're in that situation, you need to be really cognizant of how you are conducting yourself, because if the other side is super manipulative, they could start a fight, call the police, blame it on you, and now you're in handcuffs. Yeah. So, and especially if the kids are around, you're not going to want to engage in a big fight with the kids there, because that can be used against you. And so I think you're going to have to really separate reason from emotion, which is obviously really tough in these situations. and start creating an exit strategy. Because if you're going to stay in this place that's highly toxic and highly volatile, it's not going to go well. There's going to be friction, confrontation. And so what can you do to separate yourself or to start getting out of that situation and avoid the domestic violence if possible? I mean, obviously, it's like you said, it's easier for an outsider to talk about, but this happens for both genders. I'm not just talking to women, because there can be violent women too that prey upon, weaker men. And it's really a tough dynamic for men because they're supposed to be the tough guy. They're supposed to not be abused by a woman physically, or I think even emotionally is really the societal norm. And so I have so many cases too, where men will be like, oh, it's okay. Like they don't want to push it because it's kind of embarrassing to be like, yeah, my wife abused me physically, So I really think you've got to analyze the situation and do what's best for yourself, which likely means separating as soon as possible. And, one thing that the court can help with is getting money on your side. If you leave, especially in a divorce context, you can petition the court and ask the court to order the other side to give you money for spousal maintenance, for division of liquid assets, for attorney's fees. And so, even if money is an issue, that may be something to consider. Okay, what can I do at least to go to the court to get some money so that I can have more independence?
Yeah. And the other thing to consider is there are divorce funding agencies that will give you an advance on your community property. So let's say that you don't have access to money. And in Maricopa County, it's hard to get the courts to give you enough money to actually litigate your case. There are companies that will give you an advance on your, let's say you've got $200,000 in equity in your house. They might give you 40 or 50% of that you can live on, that you could use for litigation, and then they get paid out of the house proceeds. Pretty cool.
Yeah, those services have popped up in the last, 10 years or so, 5-10 years. And they're expanding just because of this problem with one side grabbing onto the finances and holding on. And it becomes a problem until things are finally settled up.
Mm-hmm. Mm-hmm. So we're not going to go over nuts and actually, there's one other thing I want to talk about. If you are in a high conflict, abusive situation, but you're still having equal parenting time, and maybe this person is not abusive to the children, let's talk about parallel parenting.
So this is all about how you craft your parenting plan. Are you going to craft it so that you and your ex need to communicate all the time and that you see each other at every exchange? Or are you going to set things up so that the exchanges happen through the school or through daycare or through sports? And then maybe you're only communicating through My Family Wizard or something like that. So yeah, there are some other options. And I believe that's what you're referring to as parallel parenting, where you each just have your time, you do your thing, but then you really don't have any face-to-face or any real communication.
Yeah. You set up the parenting plan so that the two of you can parent as independently and with as little communication and interaction as possible. So you want to think about, how are these finances, even things like who's paying for what. Like you can design that in your parenting plan so that there are no questions. There's no need to talk. You can get ahead of parenting issues and remove potential conflict. And so when there is a high conflict or a very difficult person, that's what you want to try to do, is lock it down and create practical barriers, not legal barriers, because you can't count on people to follow the court order. You cannot count on people to follow the court order. So you want to come up with ways that things just automatically happen. Like, for instance, the daycare agrees to just bill this credit card for half and this credit card for half, or whatnot. That's just one example.
Yeah. And then if you can get counseling for you and your kids, try to start healing from the situation, because there is a lot of emotional damage done.
Big time.
And you don't want to recreate the same relationship you just got out of. You need to heal so that you don't recreate the same thing again.
Yeah.
I wanted to just briefly touch upon orders of protection, domestic violence, and family law, because they all, oftentimes domestic violence starts there, or at least in the legal realm, there's an order of protection based on a domestic violence incident. And then that is wrapped in to whatever family law case is either pending or is later filed.
Mm.
So then the court is looking at, okay, now there's an order of protection in place. And that was, they got that issued by a court, which shows they met a standard showing that domestic violence either occurred or is likely to occur. And from there, I mean, when you get that order of protection, you can get exclusive possession of the house. You can get exclusive possession of pets. Mm-hmm. You can then take that into the family law court and get custody orders based on it. So oftentimes that's how that's how domestic violence really gets incorporated into a family law case. And that's also where some of the most shocking things can happen, because you can get kicked out of your house, on that order of exclusive possession based on the other side getting an ex parte order without you even being present, saying that domestic violence occurred and now I need sole possession of the house. So those order protection, when an order protection is issued, depending on its terms, it can really shake things up.
Absolutely. And you need to be careful, because if the court later thinks that you used this in a manipulative way and it wasn't appropriate, that could come back to haunt you. So you really want to make sure that it is appropriate.
And if you already have an underlying custody order, the order protection can really make things a little nutty, because there's all these rules within the order protection rules about how a lower court can't change a custody order. And so they can only do certain things in the lower court, and then it needs to get transferred to the higher court to actually make final rulings about how the order protection and the custody order work together. And so it can procedurally get pretty complicated.
Yeah, absolutely. And I mean, if the order of protection says that they have to stay away from the school and they have parenting time, like that can be really hard, and it can make exchanges hard. But you can have an order of protection that does protect you and that still allows for co-parenting and exchanges and drop-offs. You absolutely can. You can have an order of protection that allows for exchanges at certain times, communication about the kids, and those work.
Yeah, they do, especially to calm things down.
Yeah. The boundaries, like if you have somebody that will not respect any of your boundaries and their behavior constitutes domestic violence, which it might, even if you don't think it might, for texting you 100 times, that's harassment. Yeah. That you may have tried to set that boundary. You can get an order of protection that makes that stop. I love that. I mean, it shouldn't take that, but I love that that's there for people who need it.
And then the person served with the order of protection can request a hearing, and you only get one hearing to either modify or seek to dismiss the order. And the person who filed the protective order or the petition for protective order, they have the burden of proof. So they go first. They have to explain, why the issuance of the order was justified, how they met their burden. And then the other side gets to, cross-examine, present other evidence, and try to show that it wasn't valid. Now, this can get really hairy if gun rights have been, denial of somebody's gun rights has been brought up, because if you request a hearing and you lose, then there's additional repercussions on your gun rights. And so you kind of have to be strategic about whether or not you're going to request the hearing and how confident you are in your evidence. But I've had some people decide to just leave the order in place, even though they didn't really want to, because they didn't want additional repercussions on their gun rights other than them being away for the year. But there's something else that can happen if you challenge it and lose.
Yeah, and I'm not entirely clear on this. So I also practiced in Oregon, and in Oregon, it was automatic. If you got an order of protection against you, you couldn't own guns, period. Like that. But it's not that way in Arizona. It's like it only applies sometimes, and I don't know when those times are.
Yeah, the petitioner has to request it. Oh. And if they request, the judge has to ask some additional questions. Okay. And then the judge can decide whether or not it's prudent to take away the guns. And then they're supposed to be turned over to the local police or sheriff and held there for the duration of the order. So I know guns are really controversial. And obviously there's good cause to take guns away in certain situations. But then you also have a situation where you're a responsible gun owner. Maybe you do hunting with your kids or something. And now, you're stuck because you got into one yelling match with your wife or something. So I think just you have to look at all these different angles. And if you're the one petitioning, I think you need to look at that too. Like, should I check that denial of gun rights box or not?
There's a professor at ASU, Jill Messing. I'm trying to get her on my podcast, and she is currently doing research on developing proper risk assessments. And I think that that's really what this comes down to is we don't know how at this point, societally, judicially, family court wise, to properly assess for risk and then make orders that protect kids and other parents. We don't know how. We don't know how to know always who's telling the truth and who isn't, and what the consequences should be for whatever level of domestic violence is present. And I think that with more research and with more education, we will get there. At least that's what I'm hoping.
Yeah, it's definitely a fine line because the court's looking at due process and the real evidence instead of speculation. And that's where it becomes difficult for the courts.
All right, let's dive into some questions. Is it possible to get full custody post decree? I recently found evidence of previous domestic violence plus proving perjury. Evidence 72 ACEs, all 4 categories of child abuse.
So it sounds like this happened before the entry of the order.
Sounds like it.
I don't, that's very tough. I'm sure that the court is going to want something new in addition to the past stuff. And then I'm confused about why you wouldn't know about it, that it's something newly discovered, it sounds like. And so I'm not really sure how that would be newly discovered.
Yeah, you're going to have to talk to a lawyer. So your question is highly, highly legal and highly technical. You might be able to set aside your old order. You're not allowed to, you only are allowed to modify based on changes in circumstances that occurred after your order. So depending on what you found, you may have to set aside your old order. So this is very legal, very technical. You got to talk to a lawyer. My husband's ex-wife says he can see his son, but not take me with him. Can she do that?
I don't think so. I mean, it depends on if there's any special language in their parenting order, but in general, what happens during someone's parenting time is up to them, obviously within the bounds of the law, but the other parent doesn't get to control where you go or who you associate with. I mean, obviously there's some exceptions. There's that notification requirement if you plan to have your child around a sex offender. But aside from some of those, broad basic laws, I mean, you're allowed to do what you want to do during your parenting time.
Absolutely. Next question. Can stalking be considered domestic violence? My high conflict birth mom constantly shows up where the child is on dad's time and is interfering.
So she's saying that the mother-in-law is stalking?
The mom. So on dad's parenting time, let's say dad's at, in and out with the child and mom's showing up.
Okay.
Or wherever.
I don't know if it would be stalking, but harassment sounds like a better definition than stalking, or at least I think that's what the courts would see this as. And yeah, I mean, you could get an injunction against harassment. You could go back to the court on maybe an enforcement matter, but you're going to need to be really clear with your documentation and like your timeline of what's happened. Because if you're like, I was at Target and mom was there, they might, mom just happened to be there. And then I was at the park and mom was, so I think you're going to have to really lay out and show that this isn't just a coincidence that mom happens to be where you are, but that mom is spying. Yeah.
And if you are tempted to go show up where your child is on the other person's parenting time, don't do it. Don't do it. I have talked to people who have followed their kids out of state on vacation.
Oh,
Shown
really?
up.
Wow.
Yeah, you cannot do that. And it might, sometimes people don't know that, or they have the best of intentions, but you cannot do that. And if somebody does prove that you are tracking them and showing up during their parenting time, I absolutely think that's interfering, and think that it might not go well.
I'm curious what mom's deal is with that. Just super controlling or fearful or something. But I don't know, me as a mom, I'm like, oh, great, I get a break. Somebody else can play with my kid and I can have some downtime. Like, I love that. So
Me too. It's great. I have no reason to go stalk my children, not during my parenting time. But I do think it comes down to anxiety, hypervigilance, fear, I think. So in a custody order, who pays for the third party service that takes the parent's place for all exchanges? Unwed.
Well, that's a confusing question. At first, I thought they were asking about who pays for supervised parenting, but then she just talked about like supervised exchanges.
Yeah.
Um,
So let's pretend order protections in place. Both parents are not allowed to exchange the child. How do they make it happen?
I mean, usually there's some sort of third party that facilitates, even though technically under the order protection, you aren't supposed to communicate through a third party. You can communicate through lawyers. So if lawyers are involved, you could coordinate it that way. But yeah, this is that complication that can unfold when an order protection is issued and there's already a custody order in place. So often your best bet is to seek to have the order protection transferred to the Superior Court where your custody order was issued, and then get a hearing so that those two orders can not be in conflict, but that can take some time.
Yeah, there is no third party service that I know of that's paid that does custody exchanges. So it's essentially on you to figure out. You got to do it at daycare, you got to do it at school, you got to do it with a family member. It's usually how I see it go down. Coming from the side of false accusations, I'm so interested in anything that we can do to prove the other person is lying.
I mean, I think number one is listing out everything that you think is a lie, and then narrowing down to number one, the most compelling ones, if there's kids involved. So, things that impact the children. And number two, what can you really prove? What do you have stronger evidence on? And then kind of strategically approaching it that way. So if you're looking at a false accusation of domestic violence, that's where, you're looking for any holes in the story. But if it's a criminal charge against you, that certainly makes it more difficult, because unless and until you're cleared from the criminal court, the family law court may not be too interested in what you have to say about the incident.
Yes, I agree. I think that depositions are the best way to tell if somebody's lying. I do, because you can ask them up to 4 hours of questions. And when I've had cases where I needed to prove somebody was lying, they don't have the details. So they'll have a story, dad did X to me. Yeah. I had one case where mom claimed dad raped her on her wedding night. And this lady made up a lot of stuff, but that was one of them. And I was like, tell me, like, where were you in the room? How did this happen? What did he say? Like, ask the detailed questions. And most of the time they're unable to fill in because it didn't actually happen. So they don't have all those extraneous details. Or if there's a bunch of different, who did you tell immediately thereafter? What did you, that helps a lot. But it is hard. It's hard to prove a negative, and that's what you're trying to do, right? You're trying to prove something didn't happen, which is very difficult.
Yeah, and I learned this skill from my mentor in the law, John Churchill, to really break things down.
Mm-hmm.
We would talk to clients, we'd be like, okay, so what led up to this agreement you reached? And what were you talking about? And, like we really would go back, not just like, okay, there's an agreement. Like we would go back into all of the details. And then if we had something like, a false accusation of domestic violence, we would read through the report. We would act it out. We did this several times. We even did it in court once where he was pushing me and we showed how they were claiming that the push made the person go one way, but when you did it, in fact, you fell the other way. And it was like, no, this isn't true. And we were like in court actually doing the whole act out thing. So it's true. Once you get down into the nitty gritty details, you can start to find the lies that come out. And you're right, Billy, like the truth doesn't change.
Yeah.
The truth is clear. It doesn't change.
Right.
It stays the same. But if it's a lie, there's new things that come in and there's contradictions and it's like, okay, this stinks.
Yeah. Yeah. Discovery is your greatest friend. I love that. Thank you for telling us that. After you get DNA test results, how quickly can we speak to a mediator to come up with a plan?
Can you read that one more time? I'm sorry, I zoned out a little bit, I'll be honest.
No problem. After we get DNA results, how quickly can we speak with a mediator to get a plan?
Okay, so it sounds like you want to get a parenting plan. Well, are you looking to do private mediation or mediation through the court? If you want to do a private mediation, you could just get that set up. If you want to go through the court, then it's a matter of petitioning to establish paternity and decision-making, parenting time, child support, if you haven't already done that. If you have a case pending, there's a form, we actually talked about this in Win Without Law School this week, where either you alone or jointly, you can request that your case get referred to the court's mediation resources.
Fantastic. My husband has 2 accounts in his mother's names. Can my lawyer subpoena that?
Yes. The Rule 49 indicates that you're supposed to disclose any accounts that you have an interest in. It doesn't say you have to disclose just accounts that are in your name. It's any account that you have an interest in. So, when you do disclosure and discovery, it's broad. Like maybe you get into court and there could be some objections to keep that evidence out. But as far as the discovery phase, that should be fair game. And also when it comes to bank records, you got to realize you have 2 options. Do you want to beg the other side to produce it, or do you want to get a subpoena and go and get it directly from the court? So I would be looking, do I have enough information? Do I know the bank? I know mom's name. I know, maybe some identifying information about mom. Do I have enough to put together a subpoena to just get these records?
I do believe that you have to get permission to subpoena records in somebody else's names if the husband's name wasn't on the bank account.
I don't know. That'd be a good question. I'm not sure.
I had to in one case, but that doesn't mean that that's always how it is.
Mm-hmm.
Yeah. And I don't remember if the third party sought a protective order. Maybe that's how it went down. So if you issue a subpoena, you have to give notice, and the other party or the person you're subpoenaing can ask to have that limited. So maybe that's how that went. All right. So what if the court ordered my son to be in counseling, but dad refuses to sign the therapy consent forms?
Well, you could pursue enforcement of that in the court. I don't know if there was a particular therapist appointed, but I would be looking to take them a certified copy of the order and say, look, this was ordered. You don't need his signature. Permission. Just put this order in your file.
Yes. Always, anytime that you can achieve what you are trying to achieve without going back to court, do it. So I would be working with that therapist, or find a therapist that'll take the therapy, given the fact that he was ordered to do it. I think you have the court's authority and consent to get your child in therapy at this point.
Mm-hmm. Yeah.
My husband has issued my son a cell phone. My son does not text him or call him, but gets an earful if he doesn't call or text. Am I able to do something about this cell phone? There is a history of prior abuse.
Well, if the concern is protecting the child from dad being upset, then I might carve out some time during my parenting time, like 5 minutes or so, and be like, hey, can you just send your dad a quick hello text? That's probably the path of least resistance, is to just try to address that issue that way. And that seems to be the issue. I don't hear her saying she doesn't want him to have the phone or something like that. It's more just how dad's interacting with him on the phone. So I'd be looking to address that through the kid, most likely, because I don't know if dad would see it the same way she does.
Yeah, you have a couple options. I don't know how old your child is, but if your child is young, let's say 9, 10, he doesn't need a cell phone. You don't want him to have a cell phone. Let dad know you're going to take the cell phone. The child won't have the cell phone during your parenting time. That's a possibility. Or exactly what Julie said, just try to figure out a way to help your child not get an earful any way you can. How can you intervene on your kiddo's behalf? Can a mom get sole custody of a 2-month-old despite dad's documented efforts to parent and be involved?
Why don't you want dad to be involved? Would be my question. It's hard to answer that question without knowing more details. And that would be my first point of inquiry is, well, why don't you want dad to see the child? Because that could give me some details about why, what the basis of the court orders would be. But if you're just putting up barriers to put up barriers, then no, that's probably not going to work.
I think the question is, joint custody of a very young infant is scary. I think that's what.
And that's a good point. This idea of joint, I don't know if that was in the question, but we talked about this in a prior live, how complicated parenting with an infant is. Mm-hmm. And, can you open a dialogue with dad where you guys can co-parent in a way that, the child still gets to breastfeed, the child feels safe, all of that stuff. And if the dad really wants to work with you on those points, that would be great. If he does it and just wants his time, that, it can be very challenging. Mm-hmm. And Billy, I think you did a short video about this recently, or maybe it was older and I just saw it, but about a court in Virginia ordering a mom not to breastfeed to facilitate custody.
Yeah, that was crazy. Just crazy. And I don't know if it ended up getting set aside, because that's not something the court should be ordering. You know what I mean? A court can't tell mom whether or not to breastfeed, in my opinion. That's just not up to the court. Mom is allowed to pump, mom is allowed to breastfeed. That's just not within the court's ability to rule, in my opinion. But I also have a podcast episode that I did where I'm talking to a couple that split up very early on. I think they split up in their pregnancy, and they managed to work together to work out a plan that both of them could live with. And they did it. I know. I had never heard of this. And so I'm so happy that they came on the podcast and they talked about how they navigated, when to start overnights and how they compromised and how they respected one another. And they got there. Was it exactly what mom wanted? No. Was it exactly what dad wanted? No, but they got there. And then by the time I was talking to them, their kiddo was a preschooler. And how I got in contact with them? They are preschool parents at one of my employees' preschools. And this person, my employee, didn't know that they weren't together, and then found out that they weren't together and that they were co-parenting this well, and then asked them if they would be on the podcast. And that's the ideal, right? That's the dream, right? We co-parent so well that nobody knows they're not together. I just love that.
It is. And it's kind of that concept of conscious uncoupling. Does it have to be a fight? Does it have to be this knockdown, drag out, or can you separate and respect each other? And a couple of weekends ago, I was talking to a friend of mine. We were at the park and our kids were running around, and she shared this really cool concept with me, which was, when you are breaking up, can you shift from being angry and sad and hurt to having gratitude?
Mm,
Despite all the bad stuff that's happened, despite all the hurt feelings, despite the disappointment, despite maybe some violence, can you switch to being grateful for the experience, for all the lessons you've learned, for the children you created together? And it's not always easy, but wow, is it such a different place to be in than that place of anger and resentment?
right. I love that. Um,
And
one of
sometimes it takes time. I'm not saying like just suppress your anger, but maybe hold space or at least reflect upon, what is it that you're grateful for out of this relationship? Because there's something, even if it's the lessons you learned.
Absolutely. Yeah. Journaling, I think, is a really great thing because it allows you to kind of pour out all these different competing emotions. But if you can spend some time in that gratitude, in that, like, recognizing that that person did the best they could and that so did you, and that neither of you were perfect, you're just going to get to a healthier place, right?
Yeah. Yeah. Are you going to hold on to the anger and pain, or are you going to start to disconnect from that and move forward? And yeah, it's quite a journey.
Mm-hmm. If you have sole custody and dad does not exercise his supervised time, what happens?
I mean, nothing really happens in that there's not like custody police that come and crack down or something, but you could take it to the court if and when you're ready to modify and say, look, this should be modified to no time because dad's not actually exercising it. But I wouldn't want to do that after 1 or 2 missed visits. It would need to be maybe 6 months or so. And it's just a number that's not a hard and fast amount of time, but enough where this is a clear pattern that dad's not exercising his time. Because if you just come to court, oh, we didn't do it a couple times. Oh, I had work stuff come up. And, there can always be some sort of reason. So you really want to have a clear pattern.
The father of our son was arrested for strangulation of the person who's asking the question. Father is trying to obtain sole custody before he goes to trial on his DV charges. Will the family court judge let criminal court play out before awarding custody?
I mean, I don't know. I'm not really sure the status of each case, so it's hard to render a guess really about what the court may or may not do as far as the timeline goes. But in general, no, the court won't wait on the criminal matter. But the fact that the charges are there and obviously the nature of the charge is something the court's going to look at. Yeah, I'm surprised he's asking for sole custody. That's a big ask.
Yeah, the family court doesn't need a conviction to make a finding of domestic violence. Certainly a conviction is helpful, but all of the evidence that exists that would lead a prosecutor to feel like they could prove beyond a reasonable doubt something happened tells me that your family court case should be good to go if you collect all of that evidence. So that's on you to do, though. And people may not realize that, like, you have to prove domestic violence. The father has accused me of using drugs. We both took hair follicle tests. I was negative and dad popped under amphetamines. Will dad have to continue to do drug tests?
Well, keep in mind that the courts want the parties to tell the court what the parties want. So if you're wanting dad to continue to do drug testing, make a motion, motion for continued drug testing based on dad's false or negative test in particular, and then also tie in arguments about how this should impact his parenting time.
Mm-hmm. Okay, let's just do one more and then we got to wrap it up because you got to go to Win Without Law School. What happens to custody/child support if an unmarried couple reconciles? Are there any risks to that primary parent?
Okay, so you reconcile, so you're back together again.
Yeah, that's what it sounds like. So there's a custody and child support order in place, and this couple is looking to get back together. What will happen? And are there any risks to the person who, excuse me, already has custody?
So if you start living together again, the obligation to pay child support should become void because you're living under the same roof. Of course, the order is still in place. So if you're the one ordered to pay, you likely want to get a modification in place saying, hey, look, we're back together. There's no obligation to pay. Otherwise, that's going to keep accruing. It can be, there's ways to address that in the future, but that can get really complicated. So whoever's ordered to pay, if you're getting back together and living together, you likely want to at least address that issue in the court. I don't know if there'd be really, and if you're going to go back to court to address that, you could ask the court to, I guess, dismiss the custody order in total because there's no need now that you're back together. What's the risk? Well, having to do it all over again if you break up again.
And if they're unmarried, I don't know. Can you undo? I don't know. Can you say, you wouldn't undo parenting time.
If you're living together and you don't have to do a parenting plan anymore, then yeah, I'd move to dismiss the order.
I meant paternity. You don't want to undo paternity and parenting time came out. And then legal decision-making, you'd want to leave that in place because an unmarried parents who don't have any orders in place, legal decision-making defaults to mom. So you wouldn't want to do that. And if you are living together and paying child support, your money's just going from your account to their account. It's kind of a doozy of a question, isn't it?
Yeah, it is.
A lot to think through.
Yeah.
Yeah. Okay. So I know you have to get going. Let's talk a little bit about Win Without Law School. So you're at the end of your 10-week course. All of the courses have been recorded and are still available. What are the 4 different tracks and courses people can sign up for?
So the first one is for divorce with or without minor children. And that's going to take you from creating your case strategy to initiating your case to serving or responding if you didn't initiate. Temporary orders, disclosure, discovery, settlement, trial, everything's there. Or if you were never married, but you have children together, we cover child custody establishment. So legal decision-making, parenting time, child support, and again, from start to finish. And then we also look at post-decree. So you're already divorced and you have a parenting plan, or you establish custody and you have your custody order, but you either want to modify it, you want to make changes, or you want to enforce. And so we talk about that again from start to finish because the procedures are different post-decree than they are for a divorce or an establishment case. So we talk about that. And then we've got the trial skills course. So if you are going to a contested hearing on temporary orders or a final contested trial in your divorce or your establishment or your modification, we talk about how to represent yourself, how to ask questions, what the trial procedure is. So yeah, we go through all of those points. And I think it's been a lot of fun for people in addition to, getting the skills they need, but just being like, wow, there's a resource here. I don't have to just figure this all out on my own. And there's other people going through the same thing and we're all doing this together. And so I have found that the people who are in it are enjoying coming each day and learning and asking questions and empowering themselves really, because a lot of the people we're dealing with are self-represented parties who are up against an attorney.
Ooh.
They've run out of money. They can't afford another lawyer. They're generally in post-decree. And so it's great because they get to kind of figure out how do I respond? Or, is this a legitimate request? Or, we had one last week where the gal was preparing for an RMC and the other side put false allegations in their settlement paragraph saying, oh, we tried to settle, but she lied, all this stuff. And there's a clear rule in the RMC rules that says there's no argument in your proposed resolution statement. It's just your positions. And so we talked about how at the RMC, when it's her turn to talk, she can tell the judge, look, I want you to move to strike, or I want you to strike this part of the resolution management statement because it's inflammatory, it's scandalous, and it's wrong. And how cool is that to go in against another attorney and get part of their pleading stricken? I don't know what her outcome's going to be. I think her hearing's next week, but that's the kind of stuff where she wouldn't even know which direction to go in or what her options are. But at Win Without Law School, we've got answers. So
if they're interested in learning more, go to winwithoutlawschool.com. And Julie, we will be back next week. I'll see you then. Good luck.
all right. Thanks.